Hi, Mike Benoit here. This YouTube video is on the IRS taking my house through with the help of the United States District Court and tax tyranny to its max. We don't care about lost emails on this tax tyranny buster program. We care about the violation of every individual who is under the tyranny of the redistribution of production system that we have here in the United States. And that includes the victims that are made dependent by these things. Anyway, let's get back on track here. The discovery dispute issues I had with the United States government and my joint discovery dispute submission, and right into the meat of the matter here. I start off with the United States fails to give the defendant following interrogatory or answered the following interrogatory number 10. I asked for the identification of all documents classified as assessment, to which the United States responded with a plethora of documents that in no way could be classified as assessments. Remember, I'm asking for all documents classified as assessments. And their response, simply put, is nothing more than a failure to answer. And I go on and quote the Federal Rules of Civil Procedure there about evasive or incomplete disclosure. In reading the government's response to the following interrogatory, it should be apparent that it was not answered. In fact, the response is more of an obfuscation than an answer. I expect the government to identify the documents sought or state that no such documents were located. The interrogatory number 10 was to identify all documents classified as assessments by the national government of the United States, including late payment, late filing, or any other penalty assessment or interest assessments. The United States response was that they object to this interrogatory to the extent that it seeks information protected from disclosure by attorney-client privilege. The work product doctrine, 26 U.S.C. 6103, or the deliberative process privilege. Yeah, okay, I agree, that's nonsense. The United States further objects to the extent that this interrogatory seeks information pertaining to years other than 1995 or 96. Okay, fine, as it's not relevant. Subject to and without waiving these objections, the United States identifies the following documents, and they list the IRS Form 4340, which is a form that lists, has a list on it of assessments, their dates, and their assessments and their dates, and a list of any payments made. So that's for whatever. And so that's the closest thing, but it's not an assessment. It's not classified as an assessment. It's a record of so-called assessments and collections, but not an assessment. And then they list some other forms that don't even come close to that, a notice of deficiency form. That's not an assessment. All right, so I say they don't identify those things. And then my next one is that if following response to the defendant's request for identification of which code section led to the alleged liability. So I'm asking to identify the sections of the Internal Revenue Code that impose a tax on either my person, property, or any activity that I might be engaged in, and that are the subject of this action. Response: the United States objects to this interrogatory as the information is ascertainable by Benoit, as the Internal Revenue Code is public record. So I'm asking them to identify the sections of the Internal Revenue Code that impose a tax on me, my person, property, or any activity that I'm engaged in. And they object to that, saying that the Internal Revenue Code is public record. In other words, go look for it. It's in the Internal Revenue Code somewhere. The following response in interrogatory 12 is also evasive and non-responsive. Now my interrogatory 12, I asked, did you ever provide me with any documentation that stated the code section in the Internal Revenue Code that imposed a tax on me or made me liable for a tax? I'm asking them to answer, have you ever provided me with any documentation that stated the code section in the Internal Revenue Code that imposed a tax on me or made me liable for a tax? Their response was, Benoit was provided with documentation evidencing his outstanding income tax liability. I don't know if they can't read English there, they might have trouble, and so. But the question is, did you ever provide me with any documentation that stated the code section in the Internal Revenue Code that imposed a tax on me or made me liable for any tax? I don't know, maybe going to say that again because this is tax stuff. I know it's hard to understand. Did you ever provide me with any documentation that stated the code section in the Internal Revenue Code that imposed the tax on me or made me liable for a tax? Their answer, Benoit was provided with documentation evidencing his outstanding income tax liability. Does that answer that question? You might have to, yeah, you know what? We might have to go over this like 10 times because they're saying, well, we gave him, you know, he owes money. We gave him documentation showing that he owes money. I wanted to answer if they ever provided me with any documentation showing the code section that imposed the tax on me. My interrogatory number 13. I asked, if your answer to interrogatory 12 is yes, please provide the date of each delivery of such document, a description of the document, the name of the person who authored such document. Their response was, IRS Form 4549 for tax years 95 and 96, dated November 10th, 1997, letter from the IRS to Benoit, dated September 30th, 1997, IRS letter 531, notice of deficiency for tax years 1995 and 96, undated IRS Form 886 for a tax year 1995, and an IRS Form 886A for tax year 1996, dated November 10th. Well, so they answered interrogatory number 13 as if they answered number 12 in the affirmative. And Benoit was provided with documentation evidencing his outstanding income tax liability. Well, you notice that they didn't answer 12. They didn't provide me with any documentation that stated the code section. So they list all these other documents, but there's still, this whole list of documents does not list the code section that imposed a liability on them. So not answering 12, acting like they answered 12, and then listing a bunch of forms that don't relate to any document that would show a code section that imposed the tax liability on me. Now, interrogatory number 14, did you ever provide me with any original document of actual assessment of taxes for the alleged liabilities regarding this action? Response, the United States asserts that Benoit was provided with documentation regarding the assessments for his outstanding income tax liabilities, which are the subject of this action. Did you ever provide me with any original document of actual assessment of taxes? The United States says, they assert that Benoit was provided with documentation regarding the assessment. So instead of just saying, no, we didn't provide him with any original document of actual assessment of tax. They didn't. They answer it evasively, but they got away with it. Interrogatory 15, if your answer to 14 is yes, please provide the dates, etc., and they respond with the same forms that they listed before. But again, the question was, did you ever provide me with any original document of actual assessment of taxes? And they certainly did not. None of these documents they listed are an original document of assessment of taxes. Next one. So I didn't actually list everything because they didn't answer any of my interrogatories. Defendant's unresolved request for production of document issues. So I complained that my request for documents classified as assessments in the second set of production requests, request number 1, is met with obfuscation. The government is fully aware that all the documents listed in their response to request number 1 are not documents classified as assessments, yet try to pawn them off as such. Defendant expects an answer that either produces such documents or states that no such documents exist, or that they exist but are being withheld due to some lawful purpose. So the request was for produce for inspection and copying any documents classified as assessments, including original assessments, interest assessments, late penalty assessments, failure to pay penalty assessments, or any other assessments that you have that led up to the alleged obligations by defendant Michael Benoit to the national government of the United States that are the subject of this suit. Benoit has in his possessions copies of IRS Form 4340. IRS Form 4340 are routinely used to prove that assessments have in fact been made. That's not the question. That Form 4340 is used as evidence that, here's a Form 4340 and it shows the date of assessment on it. That's not the document I'm seeking. I'm seeking copying of any documents classified as assessments, not a document that's used as proof that assessments have been made that's accepted by the courts in certain circumstances. Subject to and with waiving these objections, documents responsive to this request are in the possession of Benoit and have been produced by Benoit in response to the United States' first production of da-da-da-da. Now, a request for an evidentiary hearing, they're saying they produced it, I'm saying they didn't. And they're saying that something has been used routinely to prove that assessments have been made. Doesn't negate the question or their production request. I'm looking for the assessment. I don't care what they use in court to say, hey, look, we're going to use this as proof that assessments have been made. So they obfuscate, that's obfuscation. And the request number 2, please provide for inspection and copying by the defendant Benoit any documents which reference Michael Benoit that reflect any code section that impose the tax or liability on his person, his property, or his activities that are the subject of this alleged liability in this lawsuit. I know this may be real boring stuff that nobody wants to listen to, and most people would want to continue to be either a tax slave or a depraved dependent on the system. But this is important if you want to get out of it. Please produce for inspection and copying by defendant Benoit any documents which reference Michael Benoit that reflect any code section that impose the tax or liability on his person, his property, or his activities that are the subject of the alleged liability. They respond with that the United States objects to this request is not reasonably calculated to lead to discovery. Discovery that they didn't make any assessment. Discovery of admissible evidence. Is it not admissible evidence that they have no assessments? Subject to and without waiving this objection, any documents responsive to this request are in the possession of Benoit for production of documents to Michael Benoit and the United States. If that's the case, I'm saying these documents do not reflect any code section that imposes a tax or a liability on them. They're acting like, without saying they are, because they don't want to lie, they're saying that documents responsive to this request are in the possession of Benoit. No. I just want one of them, and especially, it's just one of them that imposes a tax on me. Just, produce a document that states where, that this code section imposed a tax or liability on me. That's all. Any document that says that. They just list a bunch of documents that don't say that. Request number 4, please produce for inspection and copying by Benoit a code section within the Internal Revenue Code that imposed a tax liability either on his person, property, or activity. The United States also objects to this request is not reasonably calculated to lead discovery admissible. Asking him to produce for inspection any correspondence relating to Michael Benoit that relates to a code section within the Internal Revenue Code that imposed the tax liability. Any correspondence. So they say it's not going to lead to discovery, blah, blah, blah. And then the factual and legal analysis employed by IRS personnel is generally irrelevant and de novo proceeding. Now, for the lawyer, they understand that a IRS complaint to foreclose on somebody's home is not a de novo proceeding. Okay? And of course, you wouldn't be in a de novo proceeding. That's a proceeding that happens after the original one. The original hearing has already occurred, and you get a new hearing. Well, they're not going to allow you to get more discovery under normal conditions. So, of course, that was the case, then they would probably say, nah, you had your chance for discovery. But this attorney is calling this a de novo proceeding. Now, later on, you'll find out there's more significance to that. But that's pretty dumb. You'd wonder if this person even has a license to practice law. And it goes on and lists a bunch of things and cases. Well, let's see, maybe it's worth reading because of the de novo stuff. And then affirming that district court's refusal to compel IRS agent to answer deposition questions regarding conduct of audit because the opinions, conclusions, and reasoning of the government officials are not subject to discovery. Protective order barring taxpayer from deposing IRS agents and supervisor because opinions and conclusions of IRS officials regarding applicable Internal Revenue Code provisions were irrelevant to the merits of the case. And they go on and on and on with that. But I'm just saying that I want any correspondence relating that was relating to me that relates to a code section that imposes a tax or liability on it. on me. Of course, I'm looking and doing every way I can to find out what this code section is that imposes a liability on me. And I go around and, but then the government makes their answers to my my objections. And on interrogatory 10, they say they responded adequately to it, da, 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 da. And that's basically what they're saying on that stuff. Which, you know, maybe an evidentiary hearing would have been in due at that point in time. You know, just to be fair, kind of thing. Because I'm trying to get discovery. I'm not getting it. I'm just getting a bunch of gobbledygook that has nothing to do with the underlying case. So this does go off, and the judge makes a ruling on this discovery. It's the magistrate judge, I guess, makes a ruling on it. And some of it's interesting. Let me see if I get to the right spot on what I've got here. Oh, I make my objections, and this is important. And some of this stuff is out of order. It's like really confusing. Out of order how the court decided it and lodged it or whatever. But I make my complaints here, statement of facts, and I'm trying to get sanctions against them for not answering the interrogatory. And so I only put some of the things in there. But the relevant part of Judge M. Adler's order to this motion may be found here. So Judge Adler, he's the one that looked at our joint discovery dispute, and he came up with, you know, I lost on everything, but except one thing. And I thought, wow, this is pretty good stuff, even the one thing I won on. And he says on that, he says the interrogatory request that plaintiff identify what sections of the Internal Revenue Code impose a tax on him, his property, or any activity that is the subject of this lawsuit. The information which is relevant to the causes of action asserted by plaintiff is obviously of importance to Benoit. He raises arguments regarding plaintiff's alleged failure to produce it at several points in the joint motion, including in connection with other discovery requests. Although the interrogatory seeks specific information that is directly relevant to the case, plaintiff objected on the basis that the code is public record. Benoit is not seeking a copy of the code itself, but rather for plaintiff to identify the legal basis for the tax liability it seeks to enforce in this action. A further response, therefore, is merited. So I'm thinking, oh, that's pretty good. So what happens? So in the interrogatory, their further response, they go, pursuant to, in accordance with the court's order, dated December 9, 2009, the United States identifies the following sections of the Internal Revenue Code that are applicable to this matter. And so it lists USC, 26 USC 1, 61, 63, 3101, 6601, 6621, 6622, 6651, and 6672. All right, so some people might say, hey, you got an answer. No, because I'm asking for them to identify the sections of the Internal Revenue Code that impose a tax on either my property, my person, or any activity that I might be engaged in. So you go in there, and just some of these things, so I complain again when I'm asking for sanctions. The interrogatory did not ask for code sections that are applicable to this matter. The interrogatory asked for a code section that imposed the tax on either my person, property, or any activity. That's what the interrogatory, that's what the court ordered them to answer. But they list a bunch of these code sections, and they reword the interrogatory in their response. And they say that pursuant in accordance with the court order dated December 9th, the United States identifies the following sections of the Internal Revenue Code that are applicable to this matter. I wanted to know that impose a tax on either my person, property, or any activity, not that are applicable to this matter. So the question that I posed remained unanswered. Just for example, 2 of the code section mentioned by the plaintiff are mere definitions. Section 61 is a definition. Gross income defined. Is that a section that's imposing a tax on either my person or my property or an activity? And then section 63 defines taxable income. It's a definition. It's not an imposition of any tax. It's defining what taxable income is, not an imposition of a tax. These sections refer to interest charges and interest on underpayments, non-payments, extension of times, determining rates of interest, interest compounded daily. Defendant is still looking for an answer to his interrogatory. I want the government to identify the code section that imposed the tax in the first place on either my person, property, or activities. This response, simply put, is nothing more than a failure to answer. I go and show the federal rules of civil procedure. But as we get further into it, we'll find out that those rules don't apply to the government. I thought they might, but nope. So, and then what's this other thing? I'm trying to, that's why I wanted more time on my dispositive motion cutoff, because I'm not getting my discovery, but I didn't get the more time on that. So, and of course, I think I won or lost. So the Judge Adler's going to come back and say, yeah, they answered. Because if he says they didn't answer, and they can't produce this, they can't produce the code section and impose the tax on me, that's not going to be good for them. And in case you didn't notice, it's me against the government, with the government being the judge. That's why I want a jury trial. That's why they want to give me a jury trial, because they want to win. Okay, so that's that. This may be a good place to cut off, but this isn't the end of my discovery issues. There'll be a little bit more here. But, well, maybe it is a good place that we didn't get our discovery. So we're going to end off right there and pick up in the next one the submissions of the United States Notice of Hearing and Motion for Summary Judgment. Summary judgment is where they find you as a loser without giving you a jury trial, which is something guaranteed by the Constitution. But when's the last time a government tyrant minded the Constitution?